So good morning to everybody dialing in from the New York area. Good afternoon for those of you in Europe, as well as good evening for those or to those who are logging in from Singapore and that part of the world. This is one more event hosted by NYU School of Law Center for Transnational Litigation, Arbitration and Commercial Law. It is one of a series of events. The last one for this semester will take place next week, and it will tackle an issue already tackled on different occasions, meaning the due process paranoia and what one can do about it. That event will be co-hosted not only by the center, but also by the Dubai International Arbitration Center. Today, it's about something else. Today is about the virus of corruption in arbitration. First of all, allow me to thank our colleague, Dirk de Meulemeester, for suggesting this topic, for organizing this event, for getting in touch with our esteemed colleague who will be today with us giving the talks. We will have as a speaker, Jennifer Lim, who's joining us from Singapore, Jeremy Sharpie, who is joining us from Canada, and our very own Professor Kevin Davis from New York. Over the years, both international and domestic lawmakers have worked and have joined forces to combat corrupt activities and identify corruption as a matter of transnational public policy. Corruption issues come up frequently in the context of both international litigation and international commercial arbitration. Arbitrators deal with those issues in various ways, often relying on general principles or on transnational rules, in some cases without any regard to specific sources of domestic law. In many cases, they use red flags to identify potential corruption, and we talk about those as well today. Is this approach another example of the influence of some people would like to be an arbitral legal order that is autonomous? What standards are used when applying the red flag methodology, given that it has developed in a different setting, not within a legislative environment? How do these international or transnational standards, for that matter, factor in with the applicable law to the substance, so procedural ex arbitri or foreign loi de police? And does a disregard of these so-called red flags and ignoring potential corruption count as a violation of international public policy? And when, if so, does it count? And would such a violation justify a de novo review of the facts by national courts? These are questions that will be answered on the basis of the different applicable laws according to when the adjudicator and what adjudicators has to deal with those issues. These are only some of the issues to be tackled today in the next 75 minutes. But as I mentioned, this event is the brainchild of Dirk de Meulemeester, and I give the floor to him. Please, Dirk.
Thank you, Franco. Thank you for that introduction, and obviously thank you to NYU for hosting this event. And thank you for the helicopter view you just gave on the topic. It's true, we'll go into the topic of corruption from different angles with our speakers. All of them have a different background, as you will see, obviously all with a passion for arbitration and for the law. Corruption indeed in general is a virus, no doubt. But in relation to arbitration and arbitration proceedings, it's more like a fireball hitting the case. And that is regardless whether you are alleging the corruption or the fraud or the extortion in the case, or you have to defend yourself as counsel as a party, or when you have to take a decision as a tribunal. Now, in a dissenting opinion in the 2002 Thunderbird case, the now late, I'm afraid, Thomas Walde stated that hinting corruption is a poisonous way of litigating. as in it poisons the mind of the members of the tribunal. I think we are beyond hinting corruption in arbitration proceedings. During a seminar in Brussels in 2018, Kabir Dugal, or Dougal, who's now at Arnold and Porter in New York, said as a joke, I have to say, that as counsel in arbitration, not raising allegations of corruption in international arbitration has become professional misconduct almost. It sounds easy, but it's not. A fireball never is. And during a case, it all boils down to the burden of proof, the burden of persuasion, taking into account the law, even the legal background of the members of the arbitral tribunal, who in the end, obviously, you will have to convince either one way or the other. And it becomes even worse because at some point you will have to start taking the annulment stage into account. Now we'll give the floor to Jennifer, who is a seasoned lawyer and counsel in international arbitration. Please, Jennifer, shed some light for us on this particular topic. You have the floor, well, you have the screen for about 7 to 8 minutes. Thank you.
Thank you very much, Doug. And good morning, good afternoon, and good evening, everyone. I'm delighted to be speaking on this panel with Kevin and Jeremy and with Echo Frankos. Thank you to Doug for putting this together and for MOU for hosting. Now, today I will be addressing the standard of proof for corruption, and since I only have 8 minutes for this, it will be fairly high level, and we can always go into greater detail during the discussion and the debate. Now, why does this matter? Just to start, a finding of corruption can have serious consequences in an arbitration, for example, dismissal of the claims. And therefore, the standard of proof matters because the standard you apply directly affects whether a set of facts is considered to have crystallized into corruption. So, generally speaking, there are different evidential standards of proof, and they can be summarized as follows. The first is the balance of probabilities test. Now, this standard requires a party to establish that facts more likely than not have occurred. And this is pretty much the most common standard in international arbitration. However, when there are serious allegations of wrongdoing, such as corruption, tribunals generally demand a heightened standard of proof. So that brings me to the second standard that could be used, the beyond a reasonable doubt test. This is a very strict standard of proof that's often used in criminal law cases where one must remove any reasonable doubt in the mind of the decision maker that the defendant is guilty of the crime with which they are charged. And while rare, it is not unheard of for tribunals to apply such a test. For example, an ICC case 5622, the Hill-Martin case. The third standard, which is much more commonly used for cases of corruption, is the clear and convincing evidence test. Now, this has been described as proof in a convincing manner. It's more than probability, so it's not just a balance of probabilities, but it doesn't quite arise to the level of proof beyond a reasonable doubt. And this, as I said, has been fairly commonly applied for allegations of wrongdoing, including fraud, corruption, bribery, and other issues related to impropriety. We see that in both international commercial arbitration cases as well as international investment cases. Now, there is a minority view, however, where tribunals have not insisted on a heightened standard of proof per se, instead opting to insist on more persuasive evidence for serious allegations. In practice, however, I think that the consequences would be the same because the tribunal wants to see more to be convinced of the allegations. For example, in Libanenko in Turkey, the tribunal considered that without changing the standard of proof, allegations of fraud may still require more persuasive evidence in order for the tribunal to be satisfied that the burden of proof has been discharged. So if these are the various standards that could apply, let's say it's the clear and convincing evidence test. The difficulty with allegations such as corruption is that there's usually no direct evidence of corruption. So in such a situation, what evidence is sufficient to meet the standard of proof? Especially in situations where tribunals also often have limited power to compel a party to produce evidence. In such situations, tribunals often rely on red flags, which has been raised earlier. And it seems fairly uncontroversial, I think, at this stage that corruption may be proven through circumstantial evidence, even where a higher standard of proof applies. You have that in cases like Fraport 2, the Gato and the Slovak Republic. You also have that in Matoltek in Uzbekistan, where the tribunals all noted that corruption can be shown through circumstantial evidence. Likewise in international commercial arbitration cases. Now, the ICC guidelines on agents, intermediaries, and other third parties of 2010 set out a non-exhaustive list of 14 types of situations that they call the red flags of corruption. Now, what they mean when they say red flags is that these are circumstances that may indicate a third party's propensity to make illegal payments. They don't in and of themselves constitute violations of anti-bribery laws, but they are warning signs that indicate to the tribunal that these allegations need to be taken seriously and investigated. And there's a range of various red flags that could include payment that is out of proportion to the benefit that is to be given under the contract. It could be operating in a country that is known for corrupt payments. It could be that the third party is secretive about his identity or the identity of its owners, principals, and employees, or there's just some strange, unusual contract terms or payment arrangements. And several international tribunals have relied on these red flags to decide upon allegations of corruption. For example, in ICC case number 3916, the widespread nature of corruption in Iran was considered to be circumstantial evidence for the existence of corrupt practices during the years that the contract was being performed in Iran. And likewise, in ICC case number 8891, which involved a consultancy contract, the tribunal held that the consultancy contract had been entered into with the intent of conducting bribery and thus considered it null and void pursuant to international public policy. In reaching this conclusion, the tribunal applied 4 indicia. First is that the claimant had failed to provide evidence of his activities. The second, the short duration of the contract. Third was the manner and method of remuneration. And the fourth was that the amount payable to the agent was disproportionately high compared to the advantages obtained. In that case, the consultancy contract provided for the claimant to be paid a 40% commission. However, it is important to note that the mere presence of red flags alone is not sufficient to prove corruption. And we see this in a very recent case, Rutas Lima versus Metropolitan Municipality of Lima, which was only issued about 6 months ago and concerned a dispute under a toll concession agreement, in which the tribunal, chaired by Alexei Moore, found that there were insufficient red flags directly related to the concession agreement and thus rejected the corruption allegations, even though the standard of proof in that case was the preponderance of evidence. So you could say it wasn't that high, and even then the red flags were not enough to prove corruption. The takeaway from that case is that the mere presence of red flags does not necessarily entail corruption. If you want to tip the scale towards a finding of corruption, the proponent must prove a causal link between those flags and the event under analysis. And the tribunal would then give each red flag a proportional weight depending on the inference that it provides. Now, in the interest of time, I would just want to leave the panel as well as the audience with a few questions relating to the point that Doug mentioned earlier about poisoning the tribunal's minds. Unsubstantiated insinuations of bribery are sometimes made in a ploy to try to sway the tribunal. And in those situations, the question is, when should the tribunal investigate those claims? On the one hand, you have very serious allegations that cannot be easily dismissed, but on the other hand, additional fact-finding can increase time and costs. And if the insinuations are just not substantiated, it might not be worth taking that effort. From an academic standpoint as well, I also wanted to ask people to consider the following question, which is that with parties increasingly raising a corruption defense, whether justified or not, what measures can tribunals take besides standard of proof, besides cost awards, to try to prevent abuse of this defense? Thank you.
Thank you, Jennifer. Some interesting thoughts there. I don't know if Jeremy and Kevin want to jump in right away.
Perhaps, Dirk, just one question for Jennifer. Thank you very much for the interesting discussion. I have the sense that a lot of arbitrators are just extremely cautious about ruling in favor of a party based on a corruption allegation, based on circumstantial evidence and inferences. And I've often wondered if the standard of proof is a way in which tribunals essentially make it impossible for them to decide based on the circumstantial evidence. That is, if the standard of proof is clear and convincing evidence, then that alleviates the possibility of ruling in favor of a party making a corruption allegation based on circumstantial evidence. I was just curious for your views on this, having looked at cases, and if there are any cases actually where tribunals have applied a higher standard of proof and still have found corruption allegations proved based on red flags, indicators, circumstantial evidence, and so forth. Thank you.
Thank you. Well, that leaves a lot of food for thought. I would say, taking a step back, the standard of proof is, to me, a separate question from the type of evidence that can be used to meet that standard of proof. Even in criminal cases, where the standard of proof is higher than in these types of cases, right, beyond a reasonable doubt, circumstantial evidence can also be used. I think there's a general assumption that circumstantial evidence is somewhat weaker than direct evidence. And perhaps in most cases that is true. But I'll give an example that I learned honestly from my criminal law class in law school, which is that if you're trying to find out if someone has eaten your cookie and you're trying to find out who did it, and you see a trail of crumbs leading to someone's room, and you see a trail of crumbs around the person's mouth, I mean, assuming you don't have the testing ability to test whether those are cookies or not, yes, you didn't catch the person in the act doing it. The evidence has now been eaten, so you don't really have it, but you see that trail of crumbs, and that is all circumstantial evidence that is quite persuasive, I would say, in showing that that particular person ate the cookie. And similarly, and so I think insofar as tribunals are hesitant to use circumstantial evidence, I'm not quite sure I see that, to be honest. I think, if anything, over time, tribunals seem to have been more willing to accept that in international cases, particularly investment cases, there is some flexibility for them to decide on the standard of proof that's applicable. And whereas in the past, you had tribunals much more willing to pick a standard like beyond a reasonable doubt or clear and convincing evidence, I see tribunals increasingly saying preponderance of the evidence is enough. Now, sometimes they still say we want more to be persuaded of that standard, so query, what difference that makes in practice. But if anything, I see the opposite trend, that tribunals are more willing to hear these corruption allegations and to give more weight to them, to spend much more time on them in cases than before.
Franco, you want to jump in?
Yes, just to say a few things. I think the point made by Jeremy is a point valid in a lot of settings. What do I mean? If you have a flexible instrument, such as the standard of proof to be met, then as an arbitrator, you will use it, whether it is in this setting, in my opinion, or in a different setting. It's a different issue from, as Jennifer just said, allowing the parties actually to plead, hear the parties at length on corruption issues. But I think as an arbitrator, using burden of proof means to use a tool that it is at your disposal, and somehow, in light of the standards or the vague standards that are out there on this specific issue, I would say, it is also something that will allow you, for example, take a decision and say, no, there was no corruption. I have to say this is important because some arbitrators feel that if they were to decide on corruption-related issues, that wouldn't be very helpful for whatever reasons. But I think there is a danger that the issue of burden of proof, but more so the standard of proof that is to be met in any circumstance, whether it's corruption or any other circumstance, is a tool that arbitrators use very often.
If I may, I think flexibility, Franco, might be the magic word here when it comes to standard of proof. And following up on what Jeremy pointed out, I do wonder, and maybe Jennifer, you have some experience, or on the members of the panel, to what extent the tribunals will adapt themselves towards potential annulment proceedings. If you look at the Hague decision quite recently in the Bariven case, where the court annulled the arbitral award because the standard of proof applied by the tribunal was far too high for the annulment judge. It was clear and convincing evidence, and that was thrown out. The judge in The Hague said, if there's so much smoke, there's got to be fire, and we don't accept this decision. If you go to London, that was a whole other situation in the Alstom case. And I think actually, and I'll yield the floor, I appreciate you mentioned the case of Lima, where Alexis Moore was chairing, where there was a whole expose, as you can say, about red flags and corruption indications. And the tribunal, in fact, identified that a lot of these lights were on red, but then indeed said there's no causal link with the contract, so we will not pay further attention to it. Well, although, unless I'm mistaken, Jennifer, we still don't have an outcome when it comes to the annulment proceedings. I think they're in the US. Huh? Yeah. I wonder whether tribunals will adapt according to where the actual award will end up, potentially before an annulment judge. Anybody?
As an arbitrator, you will, of course, look into that without any doubt. If it is true that the arbitrator is supposed to render as much as possible an enforceable award, there are, in my opinion, 3 standards you will have to look at least 3 standards that come into play when, as an arbitrator, you accept to act as arbitrator. The first one is that of the seat, because that's where the annulment standard really comes from. So that's the first one, which, in my opinion, as an arbitrator, you tend to turn to very often, if for no other reasons than for guidance. You do that because, as an arbitrator, you may well have a sense that the post-award stage matters. It matters for a lot of reasons, also for some selfish reasons. You don't want to be an arbitrator whose decisions will routinely be overturned, meaning annulled, set aside. The other 2 standards, I refer to 3, the other 2 standards are clearly those of the potential place of enforcement, and I say the only ones that are relevant are the ones you know of at the time that you as an arbitrator accept to act as arbitrator, meaning where the parties, the respective parties, have the place of business. So in my opinion, these 3 regimes somehow, even though maybe not applicable to all of the issues that an arbitrator will have to decide, are regimes that the arbitrator will take into play, will take into account, and will do so on a lot of matters. Because in my opinion, the only way, or one of the very few ways, to punish, so to speak, an arbitrator to not do his or her job is actually to get his or her award annulled. Can happen once, twice, and so forth, but it should not be a routine. So as an arbitrator, you have a lot of incentives to turn to these laws. In my opinion, these 3 laws are sufficient. Why? Because that's what you agree to deal with from the outset in your arbitrator contract.
Thank you, Franco. Yeah, Jeremy.
No, I was just going to say thank you for raising the Bariven case. It's one I had in mind with this issue of the standard of proof, where tribunals traditionally have determined the standard of proof, they have identified the correct law, they've applied the facts, and they've evaluated the circumstantial and direct evidence, and they've received enormous deference from national courts, including in corruption cases. And there you see a complete role reversal here, where you have a tribunal that looks at this contract and says there are indicia of fraud, of corruption here. The contract for the sale of these engines by a US Texas-based company to the state subsidiary of the state oil and gas company in Venezuela, PDVSA. This might have been procured by corruption, but we require clear and convincing evidence of corruption, and we don't see it. We don't have that direct evidence. And then, as you pointed out, Dirk, this goes before the Dutch courts, the Hague Court of Appeals, and the court says, actually, you have the standard wrong. That standard is too high. Clear and convincing evidence in the case of corruption is too high. And what's more, there were these indicia of corruption, and that in this case is sufficient for a corruption allegation to be sustained, and that to give effect by a Dutch court would be in violation of Dutch public policy. And to set an award aside in these circumstances is really quite extraordinary. So I think Franco is quite correct that arbitrators seeing this new dynamic, perhaps in international arbitration, might reconsider how they evaluate red flags and indicia of corruption, might reconsider the standard of proof and so forth, because now the traditional deference perhaps that has been accorded arbitral tribunals is not so sure. And we might even see, as was suggested at the outset by Franco, de novo review by national courts in corruption cases. So it does seem the dynamic is changing quite a lot.
Thank you, Jeremy. The best speakers are those who don't need an introduction, and thank you for sharing what you just shared. But just for the sake of the debate, and I understand the caution of until now of what I heard, but truly from the perspective of an arbitrator, that corruption, whatever gets into the case, you wonder, is that a pussycat trying to roar like a lion? Is it a lion? Is it just smoke? Is there fire? We've touched upon the fact that different annulment courts would look at a problem from a different point of view. When it comes to standard of proof, they will apply their international public order. One judge will be more sensitive than the other. What direction are we going to take? Is it, maybe it's too early to identify, but might as well try to discuss, are we going towards some kind of stability in this particular process? Is the Alexis Moore approach that he took in the Lima case the right one? Do we have any idea where we're heading?
I think it will be interesting to see how, not only how arbitrators respond, as you pointed out, Dirk, how litigating parties will respond to this, taking in view the admonition from the Thunderbird dissent, that corruption allegations are easy to make and can change the dynamic of an arbitration proceeding, but will litigating parties use this as potentially getting a second bite at the merits at the review or enforcement stage with national courts? And will national courts follow suit like the Hague Court of Appeals? As Jennifer pointed out, the Rutas de Lima case is currently on an annulment application in the federal courts in Washington, DC. And you could imagine the tribunal following a similar trajectory that was followed in the Hague Court of Appeals and saying, look, you yourselves identified the indicia of corruption in this dispute, but you found it didn't meet the burden of proof, and it would be contrary to international public policy for a US federal court to give effect to this award. Or might the court apply the traditional deference accorded arbitral tribunals and say, you've identified the law, you've applied the law, you happen to have come to a determination that there was insufficient evidence to establish the corruption claim, and therefore the award will not be set aside. I think perhaps you're right, Dirk, that it's too early to tell which direction we're taking, but we do see some very interventionist court actions in recent years in light of the fact that corruption is becoming a much more significant problem for states, for parties, and the emphasis is really, the spotlight has been put on corruption.
Dirk, before Dirk, you give the floor to Kevin for the next issue to tackle. Just one comment that I'm reading here in the question and answer session from Michael Lampert, who is a lawyer in New York. He says, couldn't it be that the standard referred to, clear and unconvincing, is uniquely American, and that may be part of the Dutch reaction beyond the specific issue? So to say, okay, this is a reaction to something that, you know, it's so high anyway, irrespective of the fact that then certain kind of flags were raised anyway. This is something to also think about.
If I may, I read the comment of Michael Lampert, and I think he's absolutely right. We have touched upon it indirectly. It's basically the difference, the way we approach the whole concept of standard of proof from a continental law point of view, or European, what you may, and a common law. It's quite fundamentally different. I had that issue once, and then I sort of said, well, there's different approaches, but in the end, it's all the same. But I think that might have played a role indeed, that cultural quote unquote difference, whatever that means. But anybody wants to comment on that or share?
I think we should move to the.
Shall we move to the next? Okay. Well, we've been talking about red flags. We'll move to Kevin, and we have this, Jennifer mentioned the ICC note on that particular issue, and obviously we have the toolkit for arbitrators, Kevin, of the Basel Institute on Governments. I think the word toolkit is quite the euphemism, sort of sounds like you're going to work on your shed in your garden, whilst in fact having to apply red flags to me is closer to performing heart surgery. It's not really anyway. But Kevin, you have a very particular background, obviously. You've published on that subject from a different angle. And I'm referring to your book on the quiet power of indicators measuring governance, corruption, and the rule of law, 2015. One of the questions you raise is, how does the use of indicators in global governance change the nature of decision-making and the nature of law? And so the question is, are these red flags actually a safe haven? We've sort of discussed as a part of burden of proof. Obviously, are they a vaccine, to use a popular word? Or is it, and now I know Franco is going to react, is this the ultimate opportunity for those who dream about what was called earlier the third legal order, which is now called the arbitration legal order? Is this a new opportunity to introduce that idea? Kevin, please.
Right. Thanks, Dirk. So I guess you mentioned that my perspective is distinctive on this issue, because even though sometimes I think about contracts and arbitration and private law more generally, I also spend a lot of time thinking about anti-corruption regulation. And I think that the reason why arbitrators are struggling with these issues of how to deal with corruption when it presents itself in the arbitral context is because basically arbitrators are being called upon to act as regulators, right? They're becoming part of this global anti-corruption regime, whether they like it or not, or whether you like it or not, I should probably say. And so that means that you're confronting the same challenges that anti-corruption regulators face when they are trying to balance the desire to come up with effective ways of combating corruption, make sure that we don't allow for impunity and so forth, make sure that, you know, harsh sanctions essentially are imposed whenever credible allegations of bribery come to light, and that they're imposed regularly. So even though it's difficult to detect, you sort of, you know, you don't wait for the smoking gun or for the to catch the person eating the cookies, you're willing to go ahead just based on the crumbs. So on the one hand, that weighs in favor of using all the tools that arbitrators have at their disposal, which are actually quite powerful. The sanction of saying that corruption deprives an investor state tribunal of jurisdiction, that's significant when the claims can be hundreds of millions of dollars. Or if you say that it avoids the contract, it's a ground for declaring the contract void. That's again a significant penalty, even in my world or my other world, relative to the fines that enforcement agencies can impose. So the tools are there, but enforcement agencies are also finding that they have to be careful when they use those really powerful tools, when they deploy those kinds of sanctions. First of all, they have to be concerned about fairness, just basic procedural fairness. And that's obviously an issue when you're making allegations of wrongdoing based on limited evidence, shall we say, whether you've reduced the burden of proof or shifted the burden, or sorry, reduced the standard or shifted the burden, or decided to rely on circumstantial evidence, i.e. the red flags. That always raises concerns in the, say, criminal context, let's say, or the prosecutorial context. Some of the issues about allowing enforcing courts to relitigate allegations of corruption obviously raise these concerns about procedural fairness as well. So that's a concern. But then anti-corruption regulators also spend a lot of time thinking about the incentive effects of their decisions and the need to sometimes temper the sanctions that they impose to create incentives, well, not to cover things up in the first place, right? And then to cooperate with the enforcement agencies when things come to light. And then in some cases to actually engage in remedial work. And so as some of you probably know, firms can actually get significant discounts from the ordinary sanctions when they show that they not only had an effective compliance program in place, but that they actually deployed it in a way that would detect the misconduct, and then they self-report. You get a lot of credit for that under the, certainly the US regime, under the FCPA and so forth. And some of those ideas, I think, could be brought to bear in the arbitral context as well, right? So, moving away from the questions about the standard of proof and so forth, once corruption is proven, right, it might make sense to limit the consequences on the merits. So you're not throwing the case out entirely, you're only having it affect the portions of the contract that are causally linked to the allegation, for instance. So there are those kinds of moves that make sense in an effort to encourage cooperation. And then on the remediation side, this often applies to states. There's the Blau Holdings case where they essentially said to a state that was trying to raise these allegations of corruption, well, if you haven't prosecuted the officials that you say were implicated in that scheme, we're not going to entertain these allegations. You can characterize that as a shifting of the burden or something else, but I think part of that is with a view to the incentives, the idea to create incentives for states going forward to actually prosecute these claims. So I think from my perspective, it's not surprising that arbitrators and the arbitral regime generally is struggling with these issues, because the people who are engaged full time in deciding how to regulate corruption, and again, I do see this as what arbitrators are doing, are struggling with the exact same issues. And they're not necessarily relying on just the red flags, and they're recognizing that the red flags in any event will quickly become out of date as people adapt and say, oh, well, you need documentation, we can provide documentation. So they're going beyond the red flag approach, and also beyond the sort of automatic or the reflexive resort to very harsh sanctions, in part because of concerns about fairness, and then in part because of concerns about the incentive effects. So that's a perspective that I have on arbitrators as regulators. I don't know if that's a comfortable characterization for you, but at least hopefully I'm at least being provocative by suggesting that.
Thank you, Kevin. Thank you for that. a lot of questions come to mind where to some extent I understand it's a very powerful tool you have as arbitrators, but you've got to be very cautious. It's powerful, I agree, but on the other hand, as an arbitrator, you are very solitary in that specific problem because there's not much you can do apart from listening to the parties and whatever they feed you. And then, you know, sometimes it's only half the story, et cetera, et cetera. So it can be quite puzzling. We have a question, which I love it, actually. We discussed it earlier at some point, I think, Kevin, during our talks. And the question comes from Erica Levine. How do you balance it out? How do you protect yourself? And obviously it's also for the other panelists against the abuse of corruption defense when it's used as a sword and not as a shield. And then the word comes along, which I like because I've had it in a case. What if corruption exists on both sides and actually is the result of what we call extortion? Instead of, well, like corruption, obviously extortion is a way of corruption, but still, extortion is a very good word here. Can the panelists share their opinion on that particular problem?
Just to continue briefly on that, in the classic case of bribery, there's obviously corruption on both sides, or at least a prima facie case that there's corruption on both sides, because it takes two to tango. And to argue that one party or the other is being extorted is difficult, not impossible. But I know that from the perspective of the prosecutors, say the Department of Justice prosecutors in the United States who enforce the FCPA, they have no sympathy whatsoever for that claim, for claims of extortion, at least economic duress. For extortion to succeed, it has to involve threats to life or limb, basically. And they say that what you're supposed to do if someone extorts you is to just walk away, just say no. So that's one approach. I actually think that a more intermediate approach might be appropriate, where you recognize that the person who's paid the bribe has potentially had limited options. You take that into account in imposing the sanction. So you do sanction them, but it's a more moderate sanction. And if they come forward rapidly after paying that bribe, you give them credit for that. And that's why I'm not in favor of the all or nothing, or the sort of zero tolerance approach on either the criminal or the civil side. In favor of a more moderate approach that allows you to recognize that there's some culpability for not walking away, but at the same time, give credit to people who may have been extorted, but still, after the fact, put in place a program, reported, tried to clean up the problem.
No,
It's a very nuanced answer.
You did, Kevin, refer, of course, to what one could do and what has been done. So I think the most important thing is to advertise what has been done. I mean, let's suppose you have an arbitration, let's suppose you have an investment arbitration, and there was one where the arbitrators did decide to award the money which should have been awarded to party X to a non-profit organization on the basis of the fact that, in fact, you mentioned it by saying it takes two to tango, even that party somehow had to actually have accepted the bribe. So I think that is not a bad way to do it. Of course, you mentioned what is important, Kevin. You mentioned that this has to be advertised, because if this happens once in a lifetime, no consequences will this decision have. If this, however, were to happen more often, if one were able to say, okay, if my people, whether it's a company or whether it's a government, will accept bribe to get to this, later I can't claim it, and even if I can claim it, I will never get anything out of it, then maybe that can push those parties, whether it's a company or the state in investment arbitration, to do something about it, to control it themselves, rather than ask the arbitrator to do something about it. Don't you think, Kev?
I am not optimistic about the idea of states responding to financial incentives, because we're actually talking about governments and their responsiveness to incentives, and governments change, and the individuals within governments change, and they don't necessarily bear the financial consequences even while they're in office of harm to the fisc. So when it comes to thinking about incentives, the incentive effects of, say, decisions that arbitrators can make, I focus more on the incentive effects for the firms, or the very short-term incentive effects. You know, so before you launch your raise the defense, you'd better prosecute the officials. That, you know, at that level, I think there can be incentives. But in terms of financial incentives over time, I think the main effects will be on firms rather than states.
If I may, we have a question from Juliana. It sounds a bit French, Marchal or Marcal. I'm sorry, Juliana, if I say your name wrong. It's the ultimate scary question for any arbitrator out there, truly. The question is there an arbitrator's duty to report to the national authorities eventual evidence of corruption in a particular case or in a particular situation? I have the answer. From my personal perspective, it's no, but under no circumstances. But I wonder what our speakers think about that.
I was going to say, I think it might depend on the nature of the corruption. Generally speaking, I would say the party alleging corruption would be best placed to make the report. But in a situation where, say, the arbitration itself is used as some sort of, as a tool of fraud, as a tool of corruption, and then the tribunal realizes that it's basically being used in that way, the party's not going to do the reporting. And in that case, I think it would be incumbent upon the arbitrators to make that report.
All right.
I think that's right.
Okay.
To the extent that it involves money laundering in particular, not necessarily fraud in general, but money laundering laws in some jurisdictions could impose that obligation. If the arbitration itself is part of a money laundering scheme, scheme for funneling funds from a state, say, to private individual, well, to individuals.
But don't you think that this will depend, of course, on the applicable law to exactly that question, which, you know, would trigger different issues? I mean, the question would, in my opinion, be whether the anti-money laundering rules extend, of course, to this type of activity, meaning the arbitrations, that's the first thing, whether they are applicable. So these are two things. Does it extend to them? Maybe the answer is yes or it's no. But more so, are they relevant for the arbitral tribunal because of A, the seat, because of B, their citizenship, C, their residence, and so forth. So in my opinion, before one gets to say yes, these are the issues, in my opinion, that have to be looked at. And I'm not saying no, I'm just saying from an arbitrator's perspective, these would be the minimum issues to look into.
I agree. Sorry, Jeremy.
No, I was just going to say, I wonder, going back to Kevin's observation, if this isn't really a deeper question about the nature of international arbitration and changes occurring. But if you go back even 25 years ago to the Westacre case, where the tribunal specifically said, we're in service of the parties. If the parties don't raise bribery, we don't look into it. And the process is confidential. So for the traditional approach, where you're in service of the parties and it's a confidential approach, it would never cross the arbitrator's mind to become not just watchdogs, but hound dogs to sniff out corruption, to refer corruption to national prosecuting authorities. That only works if that's the expectations of the parties, and that is supported by national courts in confirmation or set-aside proceedings. But if in fact we're shifting away to a mandate where the arbitrators might have a broader responsibility, where the attitudes toward corruption have shifted internationally, where arbitrators are considered part and parcel of a solution to this broader problem of the virus of corruption, then perhaps there will become an expectation that arbitrators will refer corruption to national authorities, but I would anticipate that that would come from national authorities in the first instance to provide some clear rules rather than arbitrators blazing the trail here, because still they want to stay within their mandate and they don't want to be seen as stepping beyond that.
Jeremy, thank you very much. Two follow-up questions, if I may, and I just want to very shortly come back to what Franco said when it comes to reporting to authorities, etc. I think it would, for the greater part, depend on where the arbitrating is finding him or herself. I remember when we drafted the law, which eventually became the 2013 Belgian arbitration law, that on the level of Parliament, there was an amendment saying that arbitrators would have to report corruption, etc., etc. Luckily, we got that out of the law. Otherwise, they would have destroyed Belgian arbitration as such, I think. But nonetheless, Jeremy, just because we had a question from the perspective also from arbitrator, maybe two questions, I'll add one. One, and it sort of coincides with what Kevin earlier said. Do you think that when there are parallel criminal proceedings, which obviously relate to the case, that one, arbitrators should stay the proceedings, stay the arbitration and wait for the outcome? I'm also curious what Kevin would, from his perspective, would have on that. And a question from the audience to some extent is, what about sua ponte, investigating certain situations, potential corruption in a case, even when there's no allegations, especially, for instance, when one party is in default, that can be an issue. What about sua ponte? How far can you go in investigating, quote unquote, yourself corruption in a potential corruption case?
Perhaps on the first question, Dirk, I wonder if it's context specific in the sense that if the arbitrators sense that a respondent state, for instance, is using corruption as a means of unduly, improperly influencing the arbitration, delaying the arbitration, I suppose the arbitrators might be inclined not to stay their proceedings and to carry on. On the other hand, if there are ongoing corruption investigations and prosecutions in the home state that could directly relate to the arbitration, I suspect many arbitrators would be very reluctant to proceed and get out ahead of those. So I suppose there's probably no answer specific to all circumstances, but I think arbitrators are attuned to the need to potentially allow some of the evidence that otherwise might not be obtained through an arbitration to potentially be aired, and some of these legal issues to be determined at the national level.
That sounds right to me. So to the extent that the parallel proceedings will enhance the quality of the ultimate decision in the arbitration, yes, it would make sense to wait. But I guess I don't think it makes sense to wait just for the sake of waiting, just because those criminal investigations can be very lengthy. And so you'd be sacrificing a lot in many instances if you waited for them to be resolved, especially the ones that involve multiple jurisdictions. If you waited for the last one to be resolved, you could be waiting a decade. So simply waiting for the sake of waiting wouldn't make sense. I just want to come back to one thing that Franco and you, Dirk, said about that money laundering scenario and the applicable law. That's exactly right. You'd have to figure out what money laundering regime, let's say, applies to the transaction. But keeping in mind that the sort of choice of law problem or the conflict of laws problem will be different from the sort of civil law, private law issue that arbitrators are usually dealing with. It'll be a question of when will the money laundering authorities assert jurisdiction. And just, I wanted to emphasize that because some
Absolutely,
authorities, especially the Americans, have very expansive notions of
yes,
the territorial scope of their of their anti-money laundering legislation. So merely a transaction in US dollars anywhere in the world, a wire transfer in US dollars is often going to be enough to trigger US jurisdiction for the purposes of money laundering legislation. So I just wanted to.
So, which is also why, in fact, you're completely right, Kevin, which is also why I did refer, for example, to citizenship, residence, and so forth, because we know exactly what you said, that there are certain rules that have, of course, a very wide, if not global, extraterritorial reach. So I was not considering the law applicable to the contract. I was rather looking into exactly a law that may be applicable, if at all, to arbitrations, maybe exceptions, then to what type of arbitrations, who has to be involved for it to be triggered, whether it's payment somewhere in US dollars in any country, or is it something else? Absolutely. So it was, when I referred to the applicable laws, it was not really the classical conflict of law approach, which you did also make. Absolutely, I'm 100% with you.
We have if I may, we have another question, Jeffrey Commission. I'm afraid I'm not familiar with the case which is mentioned, but I'll read it out loud and see whether any of the panelists can intervene. It sounds strange, though. On the question of mandate, did the Spentex versus Uzbekistan tribunal exceed its mandate when it strongly suggested that the respondent make an $8 million donation to the UNDP anti-corruption program under threat of an adverse cost order? Again, I'm afraid I'm not familiar with that particular case. It's apparently a very particular situation. Is there anybody who's familiar with what happened there?
Yes, I don't think the award is published yet, but it has been discussed in some academic literature. But as I understand it, there was a situation where at the oral hearing, some indicia of corruption came out in cross-examination. The tribunal then ex officio requested additional documents, which led to further briefing, and then the tribunal applied these red flags, connected the dots, and ruled in favor of the state. In this case, it was Uzbekistan under the International Investment Agreement. But I think the tribunal had the concern that I think it was Erica Levin that raised precisely, which is that, are you incentivizing the state to raise these corruption allegations without necessarily taking actions within the state to prosecute the individuals who are responsible? Or at least that's one possible concern. You see this reflected precisely in the Metaltech versus in the World Duty Free versus Kenya case, where the tribunal said, we understand that the bribe that was paid did not just go to a government official in the executive, but to the highest levels. And therefore, are we rewarding the state, so to say, by dismissing the claim against it when it otherwise might have to pay? And so in the Spentex case, as I understand that's been reported, there was this obligation to pay in a sense to ensure that the state bears some consequences for the corruption findings that the tribunal made. I think it's an interesting approach. My own preference would be if this would be dealt with by states collectively, because to have arbitral tribunals fashion a remedy to deal with this broader problem of what to do in preventing states from benefiting from their own. I would not like to see this ad hoc in an inconsistent manner, but it's a problem worth thinking more deeply about. I think at the international level, some clear guidelines and approach in this regard.
That is very interesting indeed. Are we still on, or yeah?
Yes, I think Kevin wanted to raise an
issue.
Yeah,
I have a follow-up question too. Kevin, go ahead, please.
Well, just a slight gloss on that response from Jeremy. I think it's significant that it was an investment case as opposed to a commercial case. And so I think that my view is that in investment tribunals, have a slightly different mandate. It is more, I think there's a stronger argument to be made that their mandate should be informed by general concerns about international law and the international norm against corruption. So, or an even stronger case to be made for that. So that's step one. And then, yes, this is an issue that a lot of people are grappling with of, well, let's say a state is entitled to some sort of compensation for corruption, right? But the state itself was implicated in the corruption, or is the kind of kleptocratic state that can't be trusted to not misuse any funds that are received. What should you do in that circumstance? What sort of remedy should be provided? And there have been enforcement actions as well as arbitrations in which these sort of ad hoc solutions of payments to some sort of international organization or NGO or combination of the two have been implemented. It may be better that there was some sort of top-down approach created by the international community. But I think we do actually need to see some of this experimentation actually, or more of this experimentation on this ad hoc in this ad hoc fashion for a while before we have a sense of what the best way to go is. So maybe over time we can get to the overarching solution, but I think we're some ways from that.
I didn't know the case, and I apologize to the audience. I didn't know that particular case, but it is actually quite interesting, and it sort of coincides to some extent with the word extortion that we used when a tribunal would see or come to the conclusion that actually, especially in relation to a government, that there is sort of a certain corruption level going to the highest levels of a particular government. That is something that I think about a year and a half with the bomb that exploded in the figurative bomb that exploded in Argentina with the whole corruption scandal with the bags of money, et cetera, it was to the highest level of the presidency. Still all to be proven, I guess, but nonetheless. But Kevin, just another follow-up question, because we talked about staying proceedings when there's parallel criminal proceedings. If one party in an arbitration says to the other, you are corrupt, and et cetera, for such and such reason, to what extent do you think a tribunal should tell the parties, listen, you are barking up the wrong tree. If you yourself do not launch criminal proceedings against that particular party based on these allegations of fraud, then there's not much I can do for you. How does that intertwine or interact? Does that make any sense?
It does to me. I think that's certainly from this incentive-based approach, encouraging the state to bring those proceedings. Yes, so I tend to like thinking in terms of incentives, so I'm in favor of that. Of course, if they have a good excuse for not initiating the proceedings or for not following through on them, then you should accept that kind of excuse. But it strikes me as a nice solution to in a lot of cases.
Wow, okay. Interesting.
I just wanted to note that while tribunals obviously don't have powers to compel any parties to launch criminal proceedings, they could say, and they've done this before, that the failure to launch such criminal proceedings is an indicator that those allegations themselves don't hold that much weight.
Yeah, I fully agree. Obviously, a tribunal does not have that particular power, but it can use it in its way. It starts to motivate a certain award. And at the same time, I'm reading another question from Peter Freeley. To what extent are arbitrators incentivized to reach the right decision on serious illegality, particularly if a case can be decided on alternative, less controversial grounds? There is no de novo review on public policy at the seat. Kevin, you want to? Oh, I thought you wanted to share something. All right.
Well, I would just note that I think this is a very common phenomenon in international arbitration, where it seems that arbitrators would find other grounds to rule rather than relying on corruption. But I think it's also an evidentiary question that arbitrators in general, at least in my experience, are uncomfortable ruling on circumstantial evidence if there is direct evidence that would provide the basis for them to rule. So they want to ground their award in the clearest evidence. And so sometimes you have this unsatisfactory result where it appears that corruption allegations receive short shrift, but I think the tribunal just wants to stay on as solid evidentiary grounds as possible. Will we see a shift now that courts have required arbitrators, for instance, in the case of the Bereaven dispute in the Hague Court of Appeals, to look at more seriously at these indicators and red flags of corruption, perhaps. But I still think we'll see arbitrators rule when they can on direct and visual evidence rather than on circumstantial evidence and red flags.
Yeah, I can fully understand that an arbitrator, if he could throw out the case on a contractual issue or contractual point or on the facts that they can steer away from corruption allegations, they might do that. But in general, what you touch upon, Jeremy, to a certain extent is what we call arbitral courage. Having to decide and look into issues and on corruption needs courage. And I do wonder if more and more cases or awards get annulled, maybe that will be the case in the future. To what extent? Because there's a particular view that is expressed during the last hour, I think, to what extent we have to be quite careful with not damaging the integrity of arbitration in sort of pushing it away, and it's not convincing enough, or you haven't taken action before state courts, or do I have to be careful there?
Well, I think arbitrators are changing, but the whole nature of the corruption issue is changing as well. So arbitrators do have greater courage, but they also have perhaps an evolving sense of their mandate. They have greater resources available in terms of checklists and guidelines and so forth. They have perhaps a incentive based on the heightened review that national courts will give them and their awards in these cases. So I think the Spentex case or some of the other investment disputes, maybe they are different in that they are under international investment agreements, but we do see real arbitral courage in some of these cases, but it's not happening in a vacuum. The whole nature of the international community's approach to corruption has changed over the past couple of decades, with more national laws criminalizing corruption, with more domestic prosecutions, with more international conventions being concluded, and with more guidelines being issued for arbitrators to use and apply, which is definitely influencing their perception of their mandate, the parties' expectations, and I think national courts as well. So arbitrators are operating in this new milieu, and I think we will continue to see changes as the system evolves.
We're getting close to the end. There's another, maybe final question, Franco. I don't know how we're on time, from Erica Levine. It's not an easy one, I'm afraid. What happens when the lines are blurred between investor-state arbitration and commercial arbitration? For example, in a jurisdiction that does not have an investor-state rubric, the state public entities will arbitrate in commercial arbitration. What if it all starts to mingle? Anybody?
I'm not sure it should be too different, because this would presuppose that there's no corruption in commercial arbitration, which I don't think that should be.
Exactly.
Okay, so
I think there is one difference quite often, which is that in the investor state context, or in the investment context, I think that's what I have to say now. In the context of a treaty, the jurisdictional argument, the idea that corruption will go to jurisdiction of the tribunal has more of a textual basis, right? So in the legality clause of the treaty. So but I'm not a fan of resolving these issues on jurisdictional grounds. So to my way of thinking about things, it's perfectly fine if these issues are then resolved in the commercial arbitration and you lose that argument. But given the trend towards taking public policy into account at the judicial stage, I think there's a lot of convergence otherwise, right? The sort of public interest, the public policy in arbitration, in not endorsing corruption is, I think, equally relevant in both contexts now. So as far as I can tell, there's now a lot of convergence because of that, if only because of that judicial pressure.
I would say maybe that would be the case in practice, in terms of practical differences, but the legal frameworks would in theory be different, right? In an investment case, you usually apply some form of public international law. In cases where you have to have a seat, say for most commercial or commercial arbitration cases, you would then be looking a lot more at the lex arbitrii of the seat of arbitration, and let that be guiding the way, the way in which you address these claims of corruption. I would think, for example, just that for investment cases that are under ICSID, that maybe the tribunals have more flexibility in determining the applicable standards and burdens of proof, because that's less developed, I suppose, than national laws. And that they would be considering not just the public policy of the seat of the arbitration, but international public policy. Although, as I noted earlier, in practice, that might not lead to any practical difference.
Well,
Thank you, Jennifer.
That requires that you believe that there is an international public policy that comes into play at one point. I am one of those who does not believe that, not even through Article 5.2a of the New York, 5.2b of the New York Convention, it should be relevant because of the text. And let's not forget, we have investment arbitrations that are not subject to the ICSID Convention, where, of course, even for the post-war stage, then you have to turn to the commercial law regime, or meaning that regime that was basically created from the outset for commercial arbitration and now applies also to non-ICSID arbitration.
That's almost a topic for a new seminar, Franco, that you just touched upon. But unless mistaken, we used up all our time, Franco. So I guess it's back to you now.
So thank you, of course, to all of you, Dirk, for moderating, for having come up with the idea. A lot of work has been done behind the scenes, meaning prior to this webinar, the various panelists have talked to each other, and of course with Dirk. I thank all of you, Jennifer, for staying awake so late, okay, and being with us. Jeremy, and of course Kevin also. And I thank the audience. I thank the audience also for the questions, which show that this is actually an audience that knows what we are talking about, and that it's an audience that knows what type of question to ask to get some very good answers from the panelists. So I thank you all very much, and I hope to see you all at one point again in person. And to everybody, the panelists, to Dirk, the moderator, and to the audience, stay safe. Thanks a lot to everybody.